the issue about the possibility to exclude offences prior to August 2002 was negotiated at that time by the member states who adopted the framework decision. So, I mean, I don't think there is an issue of equal treatment between the member states in this regard. It's this possibility is not offered after this adoption of the proposal, and all member states which have to, new member states which have to apply the acquis for the European arrest warrant or for any other measures have to take the acquis as it stands at the moment of the accession. So I don't have any other reply. But I just want to say that we are pleased, as my commissioner said today, we are pleased, very pleased, that the situation returned to normal, to correct implementation of the European arrest warrant in Croatia. The second issue is, maybe on the just also to mention that there was a discussion in the Council, I think last year, and the Commission called on the member states which have used this possibility to withdraw it. But legally speaking, we cannot oblige the member states to do it. But of course, we would like that they withdraw these proposals, probably because with the passing of the time, the reasons why those member states have made this, has used this right, is probably over. So, is Council comparative view whether member states have adequately transposed mandatory optional? But I mean, I would just, it should justify a huge debate. I'll simply refer to the evaluation report that the Commission has adopted. The Commission has adopted 3 evaluation reports of the European arrest warrant. I think one in 2005, one in 2007, which in particular highlight clearly the situation with regard to the way the member states have implemented correctly or less correctly these grounds for refusals. In the 2011 reports, we also again mentioned this issue, especially in the annex. We are now, because 2014 is approaching, we are now in a process of assessing again all the situations. We're working with the member states to ensure appropriate, adequate transposition by all the member states before 2014. The situation is a complex issue. You have the Wolzenburg case of the ECG. It's not so obvious with regard to the optional ground for refusal to say that they are in breach or not in breach. So this is we want clearly to work with the member states to improve the situation. Lastly, universal jurisdiction. I mean, I don't think this is an issue. It's not an issue which is, or if it's an issue, it's not new. I mean, in the European arrest warrant, you have a ground for refusals in case, for example, of nebis in idem, or you have grounds for refusal, a specific ground for refusal in Article 4, Paragraph 7, I think, which relates to the question of territoriality. So you can refuse a European arrest warrant under certain conditions. But this decision does not harmonize the rules on international jurisdiction in criminal matters. So if some member states have, for example, passive jurisdiction, so that personal passive, so they prosecute offers when the victim is one of their national, for example, even if the murder was committed in another member state, and if it's not a national of the issuing member states, this has to be solved with regard with Article 4.7. And also, should mention the framework decision on conflict of jurisdiction, which has a procedure to allow member states to solve the issue of conflict of competence.
Questions are very interesting. Very interesting. Most of the member states, they execute the frame decision 2002, as I know, did not allow the EAW for crimes committed before the 2002. Italy, 2005, because the national law of Italy is 2005, and it is expressed in the law that the European arrest warrant, Italian European arrest warrant, is valid only for crimes committed after the effects of the law of application. And as I know, but I know not. I know very few. The more I work in this field, I convince myself that I know nothing. And it's very sad, very sad. I hope today I will learn some more. But seriously, as I know the national laws of application, they have the same principle, normally the same principle. And if they don't have, the courts decide of inconstitutionality, not respect of constitution for this problem. The other problem the Parliament, Mr. Greek Parliament posed is a problem of I use the Latin ne bis in idem, and it's a problem we go on till tomorrow afternoon. Mrs. Ludford. This is another problem. That is not. It's a real problem. We have the problem that to avoid that more states proceed for the same crime, also in other frames, in other descriptions. But the facts, if the facts are the same, we have the principle to not prosecute.
Thank you very much, Sarah. I'm not a politician either, so I can't speak on their behalf. I'm just a simple international civil servant, nowadays, at least. A couple of comments. On the question of Croatia, if you read the handbook on the European arrest warrant, you will find that statements were made legally, I have to say, by Austria, France, and Italy. In Italy, it was acts committed after the 7th of August 2002, and then there is a comment in the handbook saying that under Italian legislation, Italy cannot execute European arrest warrants issued before the 14th of May 2005. Then there were statements that were made which were not in conformity with the framework decision by the Czech Republic and by Luxembourg. I know that there was also a statement made by Slovenia, but it has to be said that Slovenia changed its legislation to make it in conformity with the framework decision, and Luxembourg did that as well after a while. It was if I remember well, the Luxembourg Parliament that insisted that a statement should be made, but then the government managed to persuade the Parliament that the legislation should be changed. For the Czech Republic, I don't remember if the Czech Republic has changed its legislation or not. Perhaps they have. One can read the report on them. May I also say that on the question of mandatory and optional grounds, my experience is that the member states in general have implemented this fairly. There is one problem, in my opinion, and that is that with the non-mandatory grounds, they have sometimes been made mandatory in the member states, because it should have been, at least when we negotiated it, a question for the judicial authorities to use those facultative grounds for refusal, but they turned into mandatory grounds for refusal, which has meant that judicial authorities have sometimes had problems, for instance, in transferring proceedings. I could cite several cases that have caused problems in this relation because, of course, if the law says that it is a mandatory ground for refusal, there is no possibility for the judicial authority to use any discretion whatsoever. On your question on universal jurisdiction, I do not think it has ever been discussed in the European Union, as far as I know, this issue. So your country must be a little bit unique in that respect, because most member states, they use the principle of territoriality and the principle of nationality. And when, of course, there is an issue of universal jurisdiction, certainly between the member states, one would think that where the crime has been committed, that's also where the case should be tried, certainly among the member states. Some member states that have the principle of universal jurisdiction also pose conditions, like here in Belgium, if I remember, that there has to be an acceptance by the federal prosecutor before a prosecutor can actually take up a case in relation to universal jurisdiction. Now, on the proportion